What if registering to vote required more than just checking a box, and instead meant tracking down a passport or birth certificate? What if a one-word change in a federal regulation could signal a larger shift in immigration policy? And what if the balance of power between Congress and the president could determine the price of everyday goods? This week, a bill in Congress, a federal agency decision, and a Supreme Court ruling all raise the same issue. Who has the authority to make major legal decisions? And who gets held accountable when that authority is pushed too far? That's what we are breaking down today on Wahl on Law. Hello, and welcome to the third episode of Wahl on Law. My name is Jonas Wahl, and I am a sophomore at the University of Delaware, studying political science, criminal justice, and sociology. I created this podcast because there are major legal updates every week that affect our lives, and as a student, I did not always understand what those changes meant for me. Wahl on Law breaks down how the law actually shows up in everyday life, especially for young people, students, and non-lawyers. In today's episode, we are covering 3 major legal updates. First, we are going to talk about the Save America Act, a bill that just passed in the House of Representatives and could change how Americans register to vote in federal elections. Second, we will talk about a new TSA update that changes the wording it uses for non-U.S. citizens, and why that small change is getting national attention. And third, we will cover a major U.S. Supreme Court decision that struck down sweeping tariffs imposed under emergency authority, a ruling that limits how much economic power a president can use without clear approval from Congress. Let's start with the Save America Act. Last week, on February 11th, the Republican-controlled House of Representatives voted on the Save America Act, and it passed with 218 yeses to 213 noes. This bill is backed by the Trump administration and is now in the Senate. To properly understand what's at stake, we need to look at what this bill would actually do, one part at a time. So, what is the Save America Act? The Save, or Safeguard American Voter Eligibility Act, would amend the National Voter Registration Act of 1993, which is the federal law that standardized voter registration and basically made it easier to register. Under current law, when you register to vote in a federal election, you check a box affirming that you are a U.S. citizen and sign under penalty of perjury, meaning false statements could result in fines or imprisonment. The SAVE Act would change that. Instead of just asserting that you are a citizen, you would now have to provide documentary proof, like a passport or birth certificate, to register for federal elections. It would also mandate photo ID to cast a ballot in federal elections. It doesn't change who is eligible to vote, it changes how you prove that eligibility. There are 4 major parts of this bill. First, proof of citizenship at registration. To register for federal elections, individuals would be required to present documentary proof of U.S. citizenship, and in many cases, that proof would have to be shown in person to an election official by the deadline. A driver's license alone would not be enough unless it specifically verifies citizenship, which most do not. Second, mandatory photo ID at the polls. Even if you are registered to vote, you would be required to present valid, government-issued photo ID at polling stations to cast a ballot in federal elections. And it's not just in-person voting. The bill also requires male voters to include a copy of their photo ID. Some states do already require photo ID. This would make it a national requirement for federal elections. Third, voter roll maintenance. Voter rolls are the official lists of registered voters maintained by each state. The bill requires states to establish programs to identify and remove non-citizens from those rolls. It's important to note, non-citizens are already prohibited from registering or voting under federal law. So, this provision is not changing eligibility. It is adding an additional verification layer. Fourth, legal liability for election officials. The bill would also allow legal action against election officials who register individuals without collecting the required documentation. Election officials can already face criminal penalties if they knowingly commit fraud. But this bill adds civil liability, meaning officials could face lawsuits if they fail to follow documentation procedures, even outside of criminal prosecution. Now, at this point, most people are probably asking, aren't non-citizens already banned from voting? Why is there any pushback for more safeguards? To answer the first question, yes, it is already illegal for non-citizens to vote. And data proves that instances of non-citizens voting are rare. A Brennan Center study reviewing 23.5 million votes across 42 jurisdictions in the 2016 election found 30 possible incidents of non-citizen voting, or about 0.0001% of votes cast. So the legal debate is not about whether non-citizens are allowed to vote. They aren't. The debate is about how much documentation and verification is required to enforce that rule. To answer the second question of why is there pushback, we first have to look back at the political context. Versions of the Save America Act were introduced in 2024 during the presidential election cycle. At the time, Republicans had major concerns about election integrity, particularly following disputes over the 2020 election. The bill passed the House in 2024, but did not advance in the Senate. A similar version was reintroduced in 2025 and again passed the House, but failed in the Senate. Now, with unified Republican control of Congress, the bill has a clearer path forward than in previous years. And that context matters, because opponents don't just object to what the bill does, they question why it's being introduced during major election cycles, like the 2026 midterms, and what its practical effects could be. Opponents raise four main concerns. First, access. Many Americans do not have passports. Some may not have immediate access to birth certificates. Additionally, if someone's name has changed due to marriage, adoption, or other legal reasons, documentation mismatches could create complications. All of these challenges have the potential to complicate access to the registration process. Second, implementation. If passed, the bill would require states to rapidly overhaul registration systems, retrain election officials, and update procedures, with midterm elections approaching and without any federal funding attached. Third, precedent. There is concern that this bill could open the door to additional federal election regulations. For example, there is a separate bill, the Make Elections Great Again Act, or MEGA, that would mandate paper ballots, restrict mail voting, and prohibit ranked choice voting in federal elections. That bill is not currently being voted on, but critics argue that if the SAVE Act passes, it could set a precedent that makes broader federal election reforms more likely in the future. And for reference, nearly 1 in 3 Americans voted by mail in the 2024 general election, accounting for more than 48 million, or 31%, of the total vote. It's important to note that the SAVE Act does not ban mail voting, but it would require documentary proof of citizenship to be delivered in person for mail registrations, which opponents argue reduces the convenience of mail registration. Fourth, timing. Versions of this bill have been introduced during major election cycles. First, in 2024, during the presidential race, and now ahead of the 2026 midterms. Democratic leaders argue that introducing voter eligibility legislation during election seasons raises concerns about access and participation. They say that the additional documentation requirements could disproportionately affect certain voters, which they argue may impact turnout in federal elections. Republicans, on the other hand, make three main arguments in support of the bill. First, they argue that even if non citizen voting is very rare, any instance of ineligible voting damages public confidence in elections. From their perspective, stronger documentation requirements would reinforce trust in the system. Second, they argue that election laws should be preventative. In other words, safeguards should be in place before problems become widespread, not after. They view documentary proof requirements as a proactive measure rather than just a reaction to proven fraud. Third, Republicans argue that federal elections should operate under consistent standards nationwide. Because voter identification and verification rules vary from state to state, they believe a uniform federal requirement ensures equal enforcement across the country. So, that's the essence of this debate: access versus verification, and whether federal elections should have uniform national standards. Now, where does this bill currently stand? This bill is in the Senate. Senate Majority Leader John Thune has indicated a vote may happen next week. Now, reports suggest it may have around 50 votes in support. However, in the Senate, you usually need 60 votes to pass a bill, not just a simple majority. That's because of something called the filibuster. Basically, if the minority party does not agree, they can keep debate going and block the bill from moving forward, unless 60 senators vote to end that debate. So even if the SAVE Act has 50 votes, that does not mean it will automatically pass. Without 60 votes, it can stall. So why does this matter to you? It matters to you because if this bill becomes law, registering to vote in a federal election would likely require more preparation. You may need to locate a passport or birth certificate. You may need to resolve documentation mismatches. You may need to bring a valid photo ID to vote in federal elections. For some people, that's routine. For others, it may require additional time, cost, or paperwork. And that's ultimately the core concern here. How much verification is needed to protect election integrity? And how much proof should a democracy require from the people participating in it? Okay, that's what's happening in Congress. Now, let's shift to a separate update coming from the executive branch. On Friday, February 13th, the Transportation Security Administration, or TSA, announced a change in how it will refer to non-U.S. citizens in its regulations. Previously, the agency used terms like non-U.S. citizens, but now they will use the term alien. So why is the terminology shifting? First, it's important to understand how this happened. The change was issued at the Department of Homeland Security level, which oversees the TSA. In its official explanation, DHS stated that the goal was to align TSA's regulatory language with statutory terms, definitions in the Immigration and Nationality Act, the primary federal immigration law enacted in 1952 that governs legal entry and status in the United States. In other words, the administration argues this is about consistency with existing federal law. The term alien is the word used throughout the Immigration and Nationality Act, and supporters say that the agency terminology should match the statute. It's also worth noting that this term is not new to federal law. Alien has been used in statutes for decades, and the Trump administration has used the term in executive orders and agency communications. However, terminology around immigration has shifted between administrations. For example, when President Biden was in office, he directed agencies to move away from the word alien. In fact, the U.S. Citizenship and Immigration Services Policy Manual replaced the word non-citizen in many contexts. So this is not just a small wording change. It shows a different approach to how the government talks about immigration. Now, another important part of the story is process. Unlike many federal rule changes, this terminology update did not go through the normal notice and comment period. Typically, when an agency wants to change a regulation, it must publish the proposal in advance, then allow the public time to submit comments, and finally respond to those comments before finalizing the rule. In this case, DHS determined that the terminology change does not alter any substantive regulatory requirements, basically saying there was no huge change. That classification allowed the rule to take effect immediately without a public comment period. So, what actually changes in practice? Honestly, not that much. But that does not mean that the change is insignificant. First, language in federal regulations is not just symbolic. It shapes how agencies interpret and enforce the law. The term alien is the word used in the Immigration and Nationality Act. So, supporters argue that aligning regulatory language with statutory language creates consistency. At the same time, opponents argue that terminology matters in public policy. Words used in official regulations influence how communities are perceived and how policies are framed. Immigrant rights advocates have long argued that the term alien feels dehumanizing and outdated, preferring terms like non-citizen or undocumented. Second, this change reflects a broader administrative shift. Even if the regulatory requirements stay the same, it signals how the Trump administration intends to approach immigration policy, emphasizing statutory language and a stricter interpretation of the law. Third, the process itself raises questions about transparency. Even if the terminology shift does not change screening procedures, the fact that it took effect without public input matters. The notice and comment period is one of the main ways citizens can influence federal rules. When that step is skipped, it puts more decision-making power within the executive branch and limits formal public participation. So while the immediate impact may be minimal, the broader implications are about language, administrative authority, and how executive agencies exercise discretion in implementing federal law. Now, I want to cover one more legal update from this week, and this one has real consequences for the global economy. On Friday, February 20th, the U.S. Supreme Court ruled 6-3 that President Trump exceeded his authority when he used the International Emergency Economic Powers Act, IEEPA, to impose broad sweeping tariffs. That means the tariffs imposed under IEEPA can no longer be collected going forward. Let's break this down. So first, what are tariffs? Tariffs are basically taxes on imported goods, or an extra fee added when products from another country enter the United States. When tariffs go up, imported products usually become more expensive, and that cost often lands on U.S. businesses and consumers. Tariffs have been a major tool in Trump's economic and foreign policy. In this case, President Trump put tariffs on goods coming in from almost every country, including especially high tariffs on places like China. He also added separate tariffs on products from Canada and Mexico, saying it was necessary to deal with trade imbalances and issues like fentanyl coming into the United States. According to the Congressional Budget Office, if all the current tariffs were to stay in place, they would generate about $300 billion per year for the next decade. So then why did the Supreme Court strike these tariffs down? Because of how Trump imposed them. President Trump relied heavily on IEEPA, a 1977 law designed for national emergencies. IEEPA lets a president regulate certain economic activity during emergencies. And Trump argued that this power included the ability to impose tariffs. The Supreme Court said no. Chief Justice John Roberts wrote that while IEEPA allows the president to regulate importation, that does not automatically include the separate power to impose tariffs, and the statute does not clearly give the president that taxing power. Another big part of the court's reasoning comes from something called the major questions doctrine. The idea that if the executive branch is going to do something with huge economic and political consequences, like imposing sweeping tariffs, Congress has to clearly authorize it. And in this case, the court said Congress did not. This also is not the first time the Supreme Court has used this reasoning. In 2023, the court struck down President Biden's broad student loan forgiveness plan using the same major questions doctrine. The justices said that canceling hundreds of billions of dollars in student debt was such a major economic action that Congress had to clearly approve it, and the law President Biden relied on did not clearly give him that power. So, in President Trump's tariff case, the court essentially said, we already applied this rule once to a Democratic president, and we're applying it again here. I still do want to point out that there were 3 dissenting justices that argued tariffs have historically been used to regulate imports, and that the emergency law gave the president enough flexibility to act. In their view, the court was limiting presidential power too aggressively, but they were in the minority. Now, one immediate and practical question is, what happens to the money that U.S. companies have already paid under the IEEPA-based tariffs? Economists at Penn Wharton estimate more than $175 billion have already been collected. With the court striking those tariffs down, refunds could be messy, because the ruling itself does not magically explain a clean refund system. What will most likely happen next is a legal and administrative process. Companies that paid those tariffs would probably have to file claims to get their money back, and the government would have to sort through which payments were tied specifically to the tariffs that the court struck down. And it's also possible Congress steps in to clarify how these refunds should be handled. So, while refunds are doable, it won't be instant and it also won't be simple. It's also important to note that this ruling does not erase every tariff President Trump has already imposed. It just targets the ones imposed under IEEPA. The administration has signaled it may try to keep trade pressure on by using other tariff laws, like laws tied to national security or unfair trade practices, though these alternatives tend to come with more limits than IEEPA did. That means the court's decision limits one powerful tool, but it does not mean tariffs disappear overnight, or that trade tensions suddenly end. So, why does this matter to you? It matters because tariffs don't just affect governments. They affect prices. When tariffs go up, businesses often pass these costs along, which can mean higher prices on everyday goods, from electronics to groceries to cars. This ruling could influence how much those prices rise or fall in the future. But it's also bigger than that. The court just set a boundary on how much economic power a president can use on their own. That does not just impact trade policy. It shapes how major financial decisions get made in Washington going forward. So, the headline here is simple. The Supreme Court just drew a clear line. If the president wants to impose sweeping tariffs, Congress has to clearly authorize it. That was a lot, but here is the big picture from today's episode. First, we covered the Save America Act and what it would actually change. While it doesn't alter who is eligible to vote, it would increase the documentation required to prove eligibility, including adding proof of citizenship at registration, nationwide photo ID requirements, voter roll verification measures, and potential liability for election officials. Then we looked at a terminology change from the TSA and what it signals about administrative priorities. And finally, we broke down a major Supreme Court decision that removed sweeping tariffs imposed under emergency authority. Across all three stories covered today, Congress considering voting requirements, executive agencies adjusting language, and the Supreme Court limiting presidential tariff power, the underlying theme is accountability. Accountability in Congress, accountability in executive agencies, and accountability through the courts. Before we close out, I want to say thank you for listening to the third episode of Law on Law. This was a longer episode, and if you found this episode helpful, or if it helped make the law feel a little more understandable, that's exactly the goal of this podcast. In future episodes, we will continue to break down major legal and political developments and focus on how those decisions affect everyday people, especially students. If you enjoyed this episode, make sure to follow or subscribe to Wahl on Law so you don't miss future updates. You can find episode summaries and more information at wahlonlaw.com. Thank you again for listening, and I will see you next time on Wahl on Law.